you still have to maintain your family. And when you become a missing person, you still have the duty to maintain your family. Regardless of your absentia, your family stays. So as a result of that, we shall look at what we call management of the estate of missing persons. First things first, who is a missing person? At what point do we tell that Rashid is a missing person? So this implies that under this, we have to differentiate between a missing person and a person who is presumed dead. Those two creatures are totally different. So let's start with who is a missing person. Let's start with who is a missing person. So that implies that when you are handling your workshop, you should ensure that issues are raised in that format. Okay? So your issue 1 is whether this person is a missing person. So we want to understand who amounts to a missing person. Okay? We know that we presume Jeff is married. He has gotten some sweet 60, so he has decided to go missing for 3 weeks, not knowing that he's contracting some legal marriage somewhere. So his wife Aisha advertises that my good husband is missing, not knowing that somewhere, somehow, okay, Mastu is taking care of Jeff. So will Jeff amount a person who is missing or not? So that's what we want to identify today. Someone with the law closely with the app. Okay. Okay, so let's look at section 1F of the estate of missing persons. So I kept it what it says. Okay, so let's look at F. F says that missing person means a person who disappears from Uganda without making provision for the administration of his or her estate, and investigations have shown that his or her whereabouts are not known. The catchword in this definition: 1, the person goes, okay, disappears from Uganda. What does that mean? We have looked for you in the corners of Uganda and you are nowhere to be. So the presumption is you have disappeared from Uganda. We don't know where you are. Then another catchword is that without making a provision for administration of his or her estate. Why? The presumption is when you go missing, you don't intend. Someone who intended to go missing does not leave provision to administer his or her estate. So it should disappear mysteriously. But if you leave provision for administration, that means you know you're not coming back. So you are not a missing person. Okay. Then another catchword there in is that investigations. Investigations. That what does this mean? That you should have done at least some investigations. You've tried to look for baby, but who is nowhere to be seen. Okay, is busy contracting illegal marriages somewhere. So when you look at those 3 catchwords in your facts, they should exist. Okay. Then, furthermore, when we are dealing with a missing person, okay, let's go to section 2. We are still trying to understand who is a missing person. Section 2 says that where a person in this act referred to as a missing person disappears without making provision for the administration of his or her estate or in the maintenance of his or her dependent relatives, if any, and is not heard of within 6 months. That's what I wanted. What does that mean? You should have disappeared at least 6 months. Okay? You should have disappeared at least 6 months. So that means for someone to amount a missing person, 1, you should have disappeared in Uganda. 2, without making a provision to administer your estate. 3, investigations have shown that you're nowhere to be seen. Then 4, at least within 6 months. So whenever they give you facts, count the time. If this person 6 months have not elapsed, that person is not a missing person. They can give these facts when they are 5 months and 20 days. When they are not yet 6, that person is not a missing person. It's a relaxing person. Hey. That person is relaxing. You know, these ladies are funny. You ask some, they're in school stages. Now you ask her. Sometimes when mom is so hard, say, hey, I'll go to you. They'll look for me. Mom is busy advertising. Hey, when they must is somewhere to get married. Mom is so worried, but until the 6 months expire, that's when you say, oh, master is missing. So now, these adverts missing the person, with a pic of someone who is missing. Is that person a missing person, or they just misuse that word according to the law? That person is not yet missing. Okay, so may I presume that they should use another word? Okay, hey, because under the other person has not yet been. The boy just disappears for 1 day only, and they start missing person. It's just somewhere playing hide and seek. You can. Okay, so now let's go to section 20 of this very act. Section 20 says that notwithstanding section 108 of the Evidence Act or any other law to the contrary, where a period of 3 years beginning with the date of disappearance of a missing person elapses, the missing person shall be presumed dead. The missing person shall be presumed. Now, who knows what is in section 108 of the Evidence Act? Yes? At what time is someone considered dead? 1 year and 1? That's what I said, notwithstanding. So don't consider that. Okay? Forget about that. Okay? Also, when you go to the Registration of Persons Act, section 40, the Registration of Persons Act, it is section 40, section 41, it talks about a person presumed to be dead. Okay? It says that it's not section 41, it is section 47, presumption of death. So don't consider this provision as well. Okay? Don't consider section 47. of the Registration of Persons Act. Okay, why? Section 20 says, notwithstanding Section 108 of the Evidence Act or any other written law to the contrary. So what does this mean? Okay, Section 47 says that where it is proved that the person has not been seen and has not been heard of for 7 years. So Section 47 talks about 7 years. Then Section 20 talks about how many years?
1 year.
Okay. Section 20 of the Missing Persons Act. Then Section 47 of the Registration of Persons Act talks about 7. So which law takes precedence? Okay, so when you come to the Missing Persons Act, because of its wording, it says that notwithstanding Section 108 of the Evidence Act or any other law to the contrary. So the any other law, the Registration of Persons Act is inclusive. Okay, so what does this mean? That a person to be called a missing person should be within a period of 6 months and okay, listen, notwithstanding Section 108 of the Evidence Act or any other law to the contrary, where a period of 3 years beginning from the date of disappearance of a missing person elapses, the missing person shall be presumed dead. Okay. So if I've disappeared for 7 months, who am I? If I've disappeared for 1 year, if I've disappeared for 2 years. So a person is a missing person if he or she has disappeared from 6 months to 2 years and how many days? 360, 64 days. A year has how many days?
366, so 65 days.
A year has how many days? That's a simple math. Okay, so in most cases it has 365. So what happens? That means you are a missing person within 6 months, 2 years, and 364 days. So before it clocks the 365th day, you are still a missing. Once it clocks like this, your name turns into the deceased, the late Aisha. I'm still saying that it's a meeting. So now you get it, yeah? So when you are given facts, emphasis should be put on days. Okay? Because what's going to cause you problems? Proceeding for a missing person when you need an application for letters of administration. You first get an order declaring that person dead. Then after, these are just court orders, they can be cancelled. Okay, so now do you differentiate between a missing person and a person dead? Did you guys get the case of your class?
Yes.
The only case you have workshop to earn people. This is your week. If you don't read all the cases on missing persons, but I'm sure you'll find a lady who will not read even a single word. Okay, so now we've said that this person is a missing person. Then after coming to the conclusion that this person is a missing person, then ask yourself, what are the available remedies? What are the available remedies? What are the available remedies? These remedies are divided into two. We have what we call interim remedies and then long-term remedies. Mark this. We don't have permanent remedies. So should we start with the interim remedies?
Yes.
The first interim remedy we have is under section 24. The missing persons. Okay, so we have section 24 is very emphatic. Okay, very emphatic, and it says that the catchword in section 24, for purposes of preservation of the estate, comma, maintenance of dependent relatives of a missing person, or any other good cause, court may appoint a person to be a manager of the estate of the missing person pending grant of an order. Okay, so when you are reading section 24, it provides for these circumstances under which a manager may be appointed.
Hey. Omukulu kufundanga wasinya fo sigera kudamu kufundanga nafundira mugonda.
My humble apologies. So as I was submitting that, when you look at section 24, they give you different three circumstances. So what does this mean? Your facts, they will always have either of the three. Okay? Sometimes they may have all of the three, or they may give you only one. So the first one, they are saying that for purposes of preservation, where there is a likelihoodness of distorting the estate or mismanaging the estate. So when there is imminent danger, so that the estate is preserved, court may appoint that manager. So when you look at your facts, that one is not in existence. Then the second one is maintenance of, yes, the first one is the need to preserve the estate. Okay. So they'll give you facts where one of the relatives of the missing person is desirous of selling, giving out a gift interviews, certain people have passed the barcodes. So there is a need to preserve. Someone is seriously subdividing without consent of the entire family. So there is a need to preserve. Then two, maintenance of the dependent relatives of a missing person. So the first question you need to ascertain who amounts to a dependent relative. You go back to section 2. Okay. Then you go back to section 2. Who amounts to a dependent relative? Section 2 is very clear. Wife, husband, son, daughter under the age of 18 years or above 18 years of age, who is wholly or substantially dependent on a missing person. Substantially or wholly. Even if you are above 18, okay, you are allowed, you are still called a dependent, whether you like it or not. As per the act, okay, you are still a dependent. What is required for you to prove that you are partially or wholly depending on the missing person? Only that. Okay. Then the second category we have parent, brother, sister, grandparent, grandchildren. Okay. So when after reading this, then you go back. When you go back to your facts, you have the mother and the children, not so? So that means they are dependent. And among the people you have 12 her children who are in second year, pending their end of year exams. They need tuition. Her mother, who is diabetic, receiving insulin, and then she requires treatment of her liver and the kidney, which requires a sum. And they told her she should get the same, not exceeding one month. You get it? So when you look at those facts, where do they fall? Maintenance of dependent relatives. Then the third reason they gave us is any other justifiable cause. Any other justifiable. So whatever you think of that, indeed, we need to appoint a manager. You can proceed under the same, okay? Because that is an interim remedy. Because they give the fact when there is a matter that is a bit urgent, which can't wait determination, because you never know when the application will be had. Okay, that's why in your facts they gave you a timeline of certain things. Okay, then the second interim remedy is a caveat. A caveat. Which caveat? A beneficiary caveat under 139. Forget about the one under 170, though we had it in the first workshop. But it was applicable. The registrar has powers to lodge a caveat on behalf of a person suffering from a mental illness. Though he didn't look at that. And that's how council account will tell you, lawyers, I needed a caveat on 170. Okay, we go on. So then, just the registrar on his own motion, so you don't apply. Okay. Okay. Then another remedy we may have is an injunction, temporary or interim, whatever the case may be. Okay. Depending on the set of facts you have, you may be having facts which do not warrant an injunction. Then you discuss an injunction because we discussed it in the group, my dear. Don't cause problems. Okay. Yes. So those are what we call interim remedies. Then let's go to long term. It's not, we said long term, but non-permanent orders or remedies. They are just long term. So the long term order we have is application for an order to manage the estate of missing persons. An application for an order to manage the estate of a missing person. Please note, okay, that no person is allowed to deal with the property of a missing person unless he or she has an order. When you look at section 9 of the amendment, yes, as amended in 2021, okay, in the amendment is section 4, okay. So a person who intermeddles with the estate of the deceased of the missing person commits an offense. Okay. So ask yourself, under what circumstances will someone be taken to be intermediary with the estate of a missing person? Some of you here lied before. So we are looking at circumstances under which one will be taken to have performed unlawful acts of intermediary. So you look at section 9, subsection 2. Section 9, subsection 2. We are looking at the amendment of 2020. The first act is taking possession. Okay. You take possession of this property. In section 9, subsection 2. Okay, section 9, subsection 2. The first one is taking possession. Then B, someone who refuses to deliver the property to the manager. Okay, you refuse to deliver the property to the manager. Then, or any other act related to that. So they can give you something different where this person was selling. So that means even selling is inclusive because you are dealing with the property when you don't. But please mark this. Section 9, subsection 3. Okay? Says, subsection 1 shall not apply in cases where the intermediary is by a spouse or a lineal descendant of a missing person, and it happens before the grant of an order under section 7 in circumstances prescribed under subsection 4. Okay? You get it? So where a lineal descendant or a spouse, so those ones, they don't commit intermediary. Okay, it is your father's property. So you're going to be intermediary, you need to be maintained. Okay, the spouse needs some money to make her hair. Okay, very simple like that. So now we presume that no one has intermeddled with the estate. Now we want to apply, not so. First things first, who can apply? Who can? Section 1 of the Principal Act, okay? It provided in the first place, okay? It's because it stated that Section 1 gave us the definition. When you come to Section 2, it says that where a person in this act referred to as a missing person disappears before that of his or her dependent relatives, if any is not heard within any relative. Okay, so section 2 subsection 1 says any relative. Okay, but when you come to the amendment, okay, it gave us more definitions. Okay, it gave us more definitions. It says, substituting the words daughter of above 18 years of age appearing subsection 1b1 in the words as son or daughter. Why? When we are considering any relative, remember a relative was already defined in section 1. But when you look at that, at first it had considered only who? Yes? At first it had considered only daughter. So that means a son was not eligible to, because was not inclusive in the definition of any relative. You get it? Okay? You read it in person. So we together. So now, when you look at this, when we are reading who can apply, so what you do, you come back to section 1. How it arranges those people, literally it is giving you what we call priority of who can apply, because it says a wife. So that means if the husband is missing, who has the first priority to apply? If it is the wife missing, who has the priority to apply? Husband. If it is the husband and the wife, who has the priority to apply? The son or the daughter. So that is the order we shall follow. Okay, but please mark this. Okay, a person to make this application should be of majority age. This grant is not issued to anyone below the age of 18 years. Okay. So now we've seen who can apply. Then another person need to answer, where do we apply? Jurisdictions still apply. Where do we apply? Section 3. Section 3, but mark this section 3 was amended. Why? Section 3 says jurisdictions to make a grant. Okay? Jurisdictions to make a grant. But that section was amended because it says that the magistrate 1A, because you don't have grade 2, we start with 1. Total value of the estate, where the total value of the estate exceeds 10,000 shillings but does not exceed 50,000 shillings. So that was amended, and they said that substituting the words 10,000 shillings but does not exceed 50,000 shillings appear in subsection 1B. The words does not exceed 1,000 currency points. So what does that mean? That an application to go to the magistrate grade 1, it should be of 1,000 currency points and below. So a currency point is how much? 20. That means 20,000 times 1,000. How much is that? 10 million or 20 million. So that means if the estate is worth 20 million, you go to magistrate grade, then we go back. Then what you call C is for the chief magistrate. Then you proceed to C. So chief magistrate, where it does not exceed 2,500 currency points. 2,000, okay, that is 50 million, okay, 50 million. So if the estate is of 50 million and below, but not below 20 million, you go to the chief magistrates. Then if it exceeds 50 million shillings, then we go to the High Court of Uganda. Look at the properties in your workshop. Okay, this lady had a loan of 80 million, had a property of 800 million. So that means the application goes to. Then another question you need to ask yourself, how do we apply? How do we apply? Okay. How do we apply? Section 4. Okay, section 4. Says form of application. Form of application. It says the application for a grant of an order shall be made subject to such modifications as may be necessary in the same form as the application for grant of letters of. So what does that mean? The application is by way of petition. Don't draft your notes of motion. Must. Jeff, don't draft your notes of motion. You love chamber summons. Okay. So are we together? Okay. Then we've understood how do we apply. Members, let's look at the procedure. Let's read it so that we can extract it, okay?
The maintenance of this or dependent if any of this not had within supplement relative of the missing person made with occurrence.
So it says any relative made with concurrence of the family. How do you come to that? So the first procedure is to convene a family meeting. To convene a family meeting to obtain the consensus. Then after that, to obtain a consensus, mark this, it should be in writing. It should be in writing with all signatures of the family. With all signatures of family members. Then after that, you go in section 4, drafting of the petition. drafting of the petition. 4. Then, after drafting of the petition, payment of court fees. Then, filing of the application. Do we serve that application? To who? To who? To the missing person. Okay, we don't serve them the application. So the next step will be extraction of summons, summoning the family members mentioned therein. Extraction of summons. Summon the family members under section 5. Then another step, examination. Hold on. Okay, so now, at that point, after the summons have been issued, okay, we are going for hearing, not so? But before hearing, you can lodge an objection under section 6. Okay, examination is the hearing. Okay, we first write examination. So after the summons have been issued, any person who is likely to be affected by the grant should lodge an objection. Should lodge an objection by way of a memorandum under section 6. Okay. If no objection is lodged, then court shall proceed and hear the application stroke examine the relatives. Yeah. Okay. It's by way of a memorandum. Yes. Okay, so we go on. Then after the examination and court is satisfied that the parties mentioned there, court shall proceed and grant an order under section 7. So now, after an order has been issued, then that person will become a manager of the estate of a missing person. Any question up to that? Appointed the manager now, tending to deal with the property in good faith. Okay. Then after you've become a manager, then we shall proceed and look at what are the functions of the manager appointed. What are the functions of the manager appointed? Those ones we shall all read. They are under section 8. Powers. Then lastly, what is the lifespan of an order to manage the estate of a missing person. What's the lifespan? What's the lifespan? Yes? When you look at a section 19, section 19, so once a missing person reappears under section 19, the order ceases to be useful. Okay. So once I reappear,
What happens if at all, let's say, I got an appeal granted, they are not in my finance, and during the time, the money will feel part of my property.
then that's now the selling should be with another special order of court. Where it was sold under special order of court, you can't claim. Okay, you can't claim. Then the last way how this order can cease upon mismanagement. Where you carry out any action under section, where you do anything, okay, under section 8 subsection 2 without consent of court, that is mismanagement. Once you do any act under section 8 subsection 2, okay, without permission of court, it becomes so that order can be cancelled. Yes.
If the missing person,
I beg your pardon?
if the missing person
Yes, you can, because debts also amount to estate of the deceased.
the manager can see that.
Yes,
The manager can see
exactly.
that. If you disappear, this is not. And if you can do and go away from the state.
Provided you qualify under section, the way we discussed, you went, no one knows where you are. You did, we've advertised, those are the investigations, the time, and you didn't leave any document on how to deal with your estate. Okay? Yes, but if someone knows where you are not a missing person. So the essence is no one knows where you are. So, any question on missing persons? We even discussed the workshop in there. Very simple. So why can't you go out this week? Will you die? Eh? Will you die? So, members, you guys are having your IA on Thursday as well. Okay? Friday? Yes? So, let's bring this session to an end. Thank you for attending. That is a chill week, but we have decided not to chill. And Lord bless you, grant you ease, and give you the best. Yes, of course, we are meeting tomorrow. And please mark this. Visit your work of first term and second term. Visit your work. Go and understand the following. please read marriages, because all the 2 questions will always have marriages. Question 1 will maybe on okay. It is sometimes it is funny. It cuts across. It has children, divorce, separation, and letters of administration. 1 question. Then number 2, sometimes it is on revocation of letters of. Go and read that, all those things in order. It's the last time you're having the chance. I'm telling you. Why now? You want to go back and make notes for missing persons? Why? We've done the notes here. Only go draft a petition. You sit, you go, you read letters of administration. At least you cover succession tonight. Cram the petition at least. I'm telling you, honestly speaking, go and read what we call exceptional grants. You only know 1 exception. How many exceptional grants do you know, Kathy? Have you ever heard of it? Have you ever heard of application for letters of administration annexed to the will? Do you understand what I'm saying? You get, that's what we call, those are what we call exceptional grants. Have you ever gone for guardianship order in management of the estate of a child of 10 years, of minors? Those are grants. We have what called special grants. Go and read factors that invalidate a will. They will give you facts where someone who witnessed the will was given property in the will. What is the status of that will? Please. You look at family as a relaxing point, but my dear, it will relax on you. So take it, make it a habit. The week is still fresh and virgin. Utilize it before it ends. Because next week, hey, next week isn't it civil? It's criminal. You're going to do second appeals. Okay? So let me wish you the best. Let's meet tomorrow, inshallah.